Hi, everyone. My name is Natalie Stewart. I am president of CTAReview, and thank you today for joining me to discuss the Corporate Transparency Act. What am I going to discuss on today's presentation? Well, I'm going to start with what is the Corporate Transparency Act and move on to how this applies to HOAs, what HOAs need to do, penalties for non-compliance, monitoring and updating requirements, filing options, including the CTA review service, legislation surrounding the Corporate Transparency Act, and CAI's efforts to exempt HOAs, extend the reporting deadline, and other initiatives. I'm also going to finish up with some common concerns and frequently asked questions. So jumping right into things, what is the Corporate Transparency Act? Now, I'm going to read this directly. So the Corporate Transparency Act is a federal law aimed at stopping illegal activities like tax fraud, money laundering, and funding for terrorism. It is intended to provide law enforcement with beneficial ownership information to detect this type of misconduct through business entities. According to Congress, using shell corporations and anonymously owned businesses is a widely used tactic that affects national security and economic integrity. The Corporate Transparency Act is a part of the Department of U.S. Treasury and is monitored by the Financial Crimes and Enforcement Network, which is commonly known as FinCEN. So today we are going to use a lot of new acronyms, the CTA, FinCEN, and we'll get on to BOIs and BOIRs. So now that we've discussed what the Corporate Transparency Act is, we're going to go on to why are HOAs involved at all? Well, under the Corporate Transparency Act, HOAs are considered reporting companies. Reporting companies are entities that are created in the U.S., are registered by filing a document with the Secretary of State or a similar office, such as a Bureau of Conveyances. Now, these reporting companies must file what is known as a Beneficial Ownership Information Report, or commonly known as a BOI report. And this is when the beneficial owners have to supply their identifying information about the individuals who directly or indirectly own or control the company to FinCEN. And who are the beneficial owners of an HOA? Well, those are going to be the board members. And that is because the board members are those who exercise substantial control over the reporting company or entity or association. You will also have to identify anybody who owns 25% or more of the units or homes within these communities. And now we can discuss some FinCEN exemptions. So the Corporate Transparency Act already provides 23 exemptions, most of which are big public companies like banks, stockbrokers, insurance companies, and those are the ones that FinCEN thinks already have the oversight by another agency, maybe even FinCEN or the Treasury, where the beneficial owners are already identified. Certain tax-exempt entities are also exempt, like 501c3 organizations or HOAs that were formed as 501c4 social welfare organizations. But the standard HOA that files taxes under IRC 528, no, those are not exempt. Large operating companies are exempt, and those are companies that directly employ more than 20 full-time employees and have gross receipts or sales of over 5 million. So there may be some large resort-like communities or just these large communities that are out there that may qualify under this exemption. However, we need to make sure that the employees are actually employees of the association and not of a management company. Also, unincorporated associations. So if your HOA was not created by the filing of a document with the Secretary of State or similar office, then you might qualify for an exemption because you would not be considered a domestic reporting company. I highly suggest contacting legal counsel to see if you qualify for that exemption. So if we are not exempt, what do we need to do? Well, number one, we're going to identify our BOIs. Those are our board members. And again, those are the people that exercise substantial control over the reporting company or association. And the owners that own more than 25%. Then once we have those identified, we are going to file our BOI report. There are a couple different options. You can file directly online. On FinCEN's website, they have an e-file program that anybody can use, the board members, managers, agents of the association that are designated to do this, or a third-party service similar to CTAReview. And I will go through our process a little bit later in the presentation. And once your initial report is filed, all you have to do is update within 30 days of any changes that might be made. So what information is included in these BOI reports? Well, the association has to provide a few things. First, the legal name of the corporation, and that is going to be the name that the association has on their formation documents. So if you're a community that has a different name of the association and different name in your governing documents, you're going to go back and use the official name in your formation documents. They're also requiring an address within the community. This is not an address of an attorney's office or a management company. There needs to be an address submitted that is physically on site, and the tax ID number. And our beneficial owners, meaning our board members, they are going to have to provide their full legal name, their residential address, birth date, and a copy of their identification, meaning their driver's license or passport. Once you've filed your initial BOI report, you are obligated to continually monitor and update and make any changes within 30 days. These are board member changes, driver's license or passport expiration dates, residential address changes, or possibly even a name change. And how do you update? Well, you can probably go back to your original filing service. So if you use a third-party service, you could contact CTAReview. If you filed yourself, you're going to want to go back to FinCEN and you have to file an entirely new BOI report. There's no way to access a previously submitted form. And what if you don't submit your BOI report? Well, you're going to subject yourself and your entity to potential penalties. Currently, the penalties are $591 per day for civil penalties and up to $10,000 and 2 years in prison for criminal penalties. And it's really important to note that we don't know anything about how the penalties are going to be used at this point. We do know that you can only be subject to these penalties for willful non-compliance. There is currently no definition of willful. However, it is commonly thought that you have to actively know that you need to file this information and then not do it. So if an association has never heard of this, or you got a new driver's license and you really didn't know that you needed to update your BOI report, that shouldn't be classified as willful. But again, we don't know anything at this point. I've watched a lot of FinCEN webinars and read all of the FinCEN documents that are publicly available regarding this, and the penalties are not automatic. We don't know how they will be applied or how you would even be notified that you got these penalties. So this is really up in the air, which actually makes it even scarier than knowing what the penalty criteria is. So this is why it's really important for our associations to know you do need to comply. This is law and the compliance is key. And when do you need to submit by? Well, entities formed prior to January 1st, 2024. This is going to be most of our communities. These are anything other than new development or newly formed communities in 2024. So if you were formed prior to January 1st of this year, your initial deadline to file is January 1st of 2025. If you were formed after January 1st, 2024, you have 90 days. So the clock is already ticking for communities that were formed this year. And why is this a concern? Like, why don't we all just want to submit our information to FinCEN? Board members are concerned about privacy. The information that's being asked by FinCEN is what is known as PII, which is personally identifiable information. And the information they're requiring falls into the non-sensitive and sensitive category. So non-sensitive PII is personal data that in isolation is not of significant concern, like your name or maybe your address or your birthday. But when it's all together in a certain context, it really does give some privacy concerns, especially the sensitive data that is the driver's license and passport numbers. I completely understand privacy concerns that board members have. So when you file these reports, who has access to all of this personally identifiable information? And let's just read down the list. We've got federal government agencies, state, local, and tribal law enforcement agencies, foreign requesters, financial institutions, federal functional regulators, treasury personnel, and all under the guise of stopping money laundering, corruptions, drug trafficking, fraud, and other criminal offenses. So it's quite a lot of people that could potentially have access to this information, which is why The management company perspective that I hear most often is the liability of storing all of this personal identifiable information. The data storage, management companies, they already have a lot of your PII in their systems, and adding this additional information would require them to put additional safeguards to be put in place. I can only imagine transferring of documents if there's a management transition, or if there's a new manager who's not aware of the safeguards that you need to use with PII. The liability concerns that management companies probably have over this are immense. There's also record keeping. The record keeping concerns, does a BOI report become an official record? Is there any state law surrounding this type of information? Are BOI reports considered legally protected documents? Can a homeowner request to see a copy of one? It certainly seems that would not be okay, but there's no precedent for this at this point, at least that I'm not aware of federally. So management companies are rightfully very concerned about this situation, which is why a firm like mine, CTAReview, is great to use, because we collect all the PII and we keep it off the HOA records. And what we will provide is a redacted report to the HOA for record keeping purposes. And if that report got into anybody's hands, the only information that would be supplied is the information regarding the entity and the BOI, so your board members' names.